troubles are piling up for the company behind several problematic apartment complexes across the Front Range. This after the owner of CBZ Management and their attorneys failed to show up in a Denver courtroom this morning.
Denver 7's Veronica Costa joins us in studio. And Veronica, these Denver District Court dates just keep getting continued. So what happened today?
Well, today's was actually continued from January. So that's the first thing. A Denver District Court judge wanted the owner of CBZ Management to be present in some kind of way in that courtroom today. Instead, both he and his representation failed to appear. Now, this comes after multiple legal hurdles to try and hold the owner of CBZ Management accountable for those hundreds of thousands of dollars in fines he owes for the William Penn property that's right here in Denver. That was actually closed back in January after the city deemed conditions there were deteriorating too quickly. So now only 2 CBZ Management properties remain open in the city. We spoke with the director of the Public Health Investigations Division. This is at the Denver Department of Public Health and Environment. She told us while there have been complaints, citations, and violations at these 2 other complexes, the circumstances there are much different.
What we saw at the Penn Street property was just ongoing, severe, egregious violations. And the violations at these other properties owned by CBZ at this point in time don't rise to that level.
And CBZ Management and its owner still very much in hot water. A Denver district judge ordering a warrant for them this morning.
All right, so Veronica, you said they still have 2 properties here in Denver. How much do they owe for citations on those 2 properties?
So those fines are much, much smaller than the fines that we saw over at the William Penn property. Nearly $1,000 at the Courtyard on Vine Street property, and then nearly $2,000 are owed over at the Jewel property. None of those fines have been paid either, so that's important to mention there.
Good to know. Veronica Costa reporting in studio for us tonight. Veronica, thank you.
Thanks, Veronica. All right, going in depth, the management company at the center of this has filed its own lawsuit, CBZ Management, suing the Colorado Attorney General over an investigation into their practices. The AG wants to determine whether CBZ broke any state laws having on safe housing and consumer protections. But CBZ claims the AG has not explained why it believes the company may have broken the law.
And digging deeper here, CBZ Management gained its notoriety after this video went viral, showing armed men going door to door at one of its apartment buildings, the edge of Lowry. At the time, President Donald Trump and conservative media outlets repeated claims that Venezuelan gangs were running the apartment complex, charging rent, and even had taken over the city. Now, the mayor in Aurora and police chief have said that, yes, there were problems and even arrests of some gang members there. But the chief says gangs had not taken over any of the complexes. And last month, the edge of Lowry was fenced off and vacated.
Because of widespread issues in multiple apartment complexes in Aurora and Denver, we wanted to take an in-depth look at what people can do if they're in this position.
Joining the conversation now is Jeff Pesciut, Director of Real Estate at the College of Business at Metropolitan State University of Denver. Jeff, thank you so much for joining this conversation.
Thanks for having me.
And we want to get right to this. What rights do you have as a renter if you feel it's unsafe or poorly maintained, but you are in a lease agreement?
Well, first of all, under Colorado statutory law, in any residential rental agreement, the landlord is deemed to warrant, which means promise, that the premises will be fit for habitation.
The warranty of habitability, we hear about this a lot.
Right, it's called the Colorado implied warranty of habitability, and that's a good point. It's implied. It doesn't have to be explicit in the lease agreement. It's inserted in the lease agreement by law.
All right, so let's say you made the request for maintenance about a safety issue that needs to be addressed, and they're not responding. So what recourse do you have if you feel like you're being completely ignored?
Well, first of all, the law also deems that the premises are uninhabitable if certain conditions exist or don't exist. For instance, mold. That's automatically uninhabitable if there's the presence of mold. Other conditions would be, say, lack of waterproofing or weatherproofing, lack of functioning heat, lack of electricity, and so on. Failure to comply with local building codes, housing codes, or health codes. Those are all deemed to be a lack of habitability. And so, to answer your question, if there is if any of these conditions exist or don't exist, the first thing that the tenant should do is provide written notice to the landlord about these concerns or problems. And one of the things that's very important is that they send the notice to the landlord at the notice provisions contained in the lease agreement. So you can't just send it anywhere. You have to send it to the location or through the means that are identified in the notice provision in your lease agreement.
You have to jump through the right hoops, and then...
Right. And so then the landlord has essentially 24 hours to provide a plan by which they're going to remedy the situation. Mm-hmm. And if the landlord doesn't provide that plan within 24 hours, and you've provided the written notice that I mentioned, then the landlord's now in breach of the implied warranty of habitability.
And then can you then break your lease?
Well, then you have a number of remedies available to you. One of them is to withhold rent. Another is to terminate your lease. Another is to seek an injunction from a court of law that tells the landlord to correct the situation. Another is to sue for money damages. Say you had to move out and rent a hotel room for a period of time, or say you had to purchase a space heater to keep the space warm. Then you can sue for money damages in a court of law, and also your recovery can include attorney's fees and court costs.
And these are all some new protections under Colorado laws. So thank you so much for that very helpful information for people who are dealing with this.
Jeff Prostitute with MSU Denver, we really appreciate your time. Thank you.
Thank you.